What are human rights and why do they matter? Human rights are basic rights and freedoms everyone has just for being human. They make sure people are treated fairly and aren't discriminated against or punished for things like their beliefs or opinions. These rights help build a very fair and safe society. They protect everyone from unfair treatment. Now, they matter because they set the ground rules for how people should be treated, no matter who they are. The right to life, freedom from torture, a fair trial, all of these rights stop society from becoming unfair or chaotic. Let's consider some everyday examples. Freedom of expression. You can share your opinions, like posting online, blogging, or talking politics with your friends, as long as you don't incite hate or break the law. So this covers things like protesting, dressing how you like, criticising the government, and you should be able to do all of this without fearing trouble. Another example is that right to privacy we all expect. Our private texts, messages, photos, these are all protected from anyone snooping without a really good reason, like in a serious police investigation, for example. Even things like CCTV are regulated, so people can't just record you anywhere. We also have freedom from discrimination. You must be treated fairly at work, at school, or in public, no matter what your race, or your religion, or gender, or sexuality, or disability. If you are mistreated for who you are, you can challenge it and sometimes take legal action. And then we have the right to education. Everyone should have a fair shot at school or college, shouldn't they? No one can be excluded for their background, money, or beliefs. And this right also supports those with special needs, so everyone gets a chance to learn. These rights are not just theoretical, they have real practical impacts on how we live our lives every day. Let's move on to consider the significance of human rights law. So, human rights law is the area of the law that protects these fundamental rights, and it's deeply woven into the legal system of the UK, influencing decisions made by the government, police, schools, and courts. For example, it restricts what the police can do during a search, ensures that patients in hospitals are treated with dignity, and makes sure that schools respect students' beliefs and backgrounds. Essentially, human rights law helps maintain a balance between the power of the state and the freedoms of individuals. Let's take a closer look at the key principles involved. So, starting off with universality, very important, because human rights apply to everyone, everywhere, universally. So whether you're rich or poor, young or old, if you're a citizen or a visitor, you have these rights simply by being human. For example, the right to protection from torture, well, that applies equally, doesn't it, to everyone in the UK and abroad. Next is indivisibility. Now, what this means is that all rights are equally important and connected. For instance, if someone's right to education is taken away, it could affect their right to work or to participate in society. You can't ignore one right without potentially harming others. Next on the list of key principles is inalienability. You cannot lose your human rights, except in very special circumstances prescribed by law, like being sent to prison after a fair trial. And even then, only certain rights may be limited, and others, like the right not to be tortured, well, they can never be taken away. And our final key principle to look at is equality and non-discrimination, which we have mentioned. Everyone is entitled to the same rights and freedoms, regardless of their background. So this principle aims to eliminate unfair treatment based on things like race, religion, gender, disability, or sexual orientation. For example, laws must not discriminate against people for wearing religious symbols at school or work. We're going to move on now to look at the theoretical foundations of human rights law. It starts with natural law. Now, these are rights that exist because we're human. They're very natural and universal. So the strength of these is that they have a moral basis and they apply to all societies regardless of the law. But a weakness is that that's a little bit hard to define, isn't it? What rights would you say exist naturally? Moving on then, this addresses that problem because we've got positivism. So positivism means that rights only exist if they're recognised in law. Okay, so they're written into the law by the governments. Now, a strength of this, of course, is legal clarity and certainty. We can be certain and clear about what rights are protected. But there is a weakness too. It might miss unwritten moral rights and also not protect rights that are not yet recognised by the law. And finally, we have social contract as a theoretical foundation. This means that rights come from an agreement among people to form a society and government. In terms of strengths, it reflects democratic values, which we value, don't we? And rights can be adapted as society changes. But a weakness is that rights may differ between societies and can change with public opinion. For example, the right to a fair trial is actually justified by all three of these. So, natural law. I think we'd all agree that a natural law is that everyone deserves justice. But also positivism. Well, it's written into the Human Rights Act as well, into the statute. And finally, social contract. It maintains order and trust in society. It's now important to just make the distinction and understand the definitions of rights and liberties. So let's take rights to start with. So what are rights? Well, our rights are positive entitlements. And that means that they're protected and enforced by the law. So, for example, the right to life means the government have to put positive steps in place. They must not only avoid taking life unjustly, but also protect it. For example, putting laws against murder into place. So that's right. So those are the positive entitlements, but we also have liberties. Now, liberties are freedoms to act in certain ways without any interference, unless the law says otherwise. So, for example, you're free to practice your religion, you're free to assemble peacefully, unless there's a specific law restricting it for reasons like public safety. Now, the difference between these two does matter. So rights often require the state to take positive action. So the right to education means that the government have to fund schools. The right to justice means they have to ensure fair trials. So those are positive actions. But liberties focus on non-interference, leaving you be. So not stopping you from speaking out or protesting. Let's now look at regulation and the role of Parliament and the courts. Now we know that Parliament makes the law. It also changes the law through reform. So, for example, Parliament passed the Human Rights Act in 1998. Now, it can also amend or repeal legislation as it's needed, which is good because that reflects the views and the changing needs of society. Then we have the courts as well. So the courts then interpret and apply those laws. They decide on disputes. They order remedies if rights are breached. So courts, they ensure that the public authorities and government bodies respect human rights, and they can strike down actions or policies that don't comply. Now, this dual system means that even if Parliament sets the law, well, the courts act as a kind of watchdog, and they protect individuals from unfair treatment or abuse of power. And we'll just finish with a couple of key cases. So let's start with R. Daley versus Secretary of State. So this was a case about a prisoner, Mr. Daley, and he took issue with a rule at his prison that let the staff search cells while inmates weren't present. And that search even included going through their private legal documents. So what was the outcome? Well, the House of Lords found the policy was unlawful because it unduly interfered with the prisoner's right to privacy and confidential contact with their lawyer. And that's protected under Article 8 of the European Court of Human Rights. This case established that any restriction on rights must be strictly necessary, producing the proportionality test, as it's known. Next, we have Hurst versus UK. another prison case. So John Hurst, who was in prison for life, he challenged the UK's ban on all inmates voting in elections. And the European Court of Human Rights actually agreed with him. And they found that this blanket ban broke Article 3 of Protocol 1 of the Act, the right to free elections. The court recognised that countries should have some flexibility, but they said the UK's approach was just too harsh and didn't really strike a fair balance. Now, this case was a really good example of the struggle between protecting individual rights and letting Parliament set the rules for voting. And one last case. So this was A versus Secretary of State in 2004. It's quite famously known as the Belmarsh case. It was about a group of foreign nationals who'd been held indefinitely, without trial, under laws brought in after the 9/11 attacks. The House of Lords decided this kind of indefinite detention went against Article 5 of the European Court of Human Rights, the right to liberty. The judges also pointed out it was unfair that the rules only targeted non-UK nationals. So in short, even when national security is at stake, the government still has to respect basic human rights and justify, indeed, any limits on freedom, making sure there are proper safeguards.